Good morning, everybody, and welcome to February 2025 Employment Coffee Break Briefing. For those of you I haven't spoken to this year, Happy New Year as well. Hope everybody had a good break and that January hasn't been too stressful for you. A few bits of housekeeping before we kick off. Those of you who are regular attendees or viewers of these sessions will know that from about the end of 2023 to the end of last year, we did a cycle through the employee life cycle, from recruitment and contracting and employment status, through those issues that crop up during the course of employment, whether that's disciplinary, sickness, absence, capability, those kind of issues, right through to the end of last year, where we concluded on termination and post-termination issues. With that last session before Christmas, that obviously took us to the end of that employee life cycle. So for this year, we're going to do things a little bit differently. We're not necessarily following through chronologically. So what we thought we would do is, for this first session, as has come out in the marketing content, look at some common issues that we see arising, the things that crop up for us as a team all the time, and sort of some general FAQs. I was getting people messaging me sort of during the course of the last month or so with things they would like me to cover. So I've tried to touch on a few of those, as well as a few things that commonly come up in feedback that we sort of didn't touch on last year, but maybe didn't warrant an entire session on. As this year progresses, I'm absolutely open to suggestions of anything anybody does want us to talk about, but we will start doing sessions involving other people. I know Nathan did 1 and 2 for me at the end of last year, so we'll bring him back on board to get a different perspective on a few things. I've got a few other maybe third-party guests lined up to have a conversation with us at some point. But if there is anything that you do want exploring during these sessions that you would find helpful, please do let me know. If not, we will just keep talking about our own thing. Other than that, a few normal housekeeping things. You know these sessions are recorded, copy of the recording and a summary is sent to everybody who signs up. All of the previous ones and this one will ultimately be made available on the Friends YouTube page. So, moving on to today's topic then, common issues and FAQs. Sorry, awkward slide there where I had to reach down and actually move my mouse across properly. What we're going to be looking through then, these are the topics that I think came out to you as a general overview. So I thought I would start by looking at some of the common inquiries that we get from employee clients. Because what I can sort of do there is talk about the advice that we're giving to employees in certain circumstances, and particularly the things that are arising most frequently. And therefore, quite simply, what you should be keeping an eye out for as a business, as an employer. I know we touched on sickness absence management towards the middle, around the summer, I think, time of last year. There were a few outstanding points from that, and it is something that we're seeing as a recurring theme. So I wanted to highlight a couple of things that arise in sickness absence management processes. We'll look at the top tribunal claims. So for those of you who don't know, every quarter, every year, the Employment Tribunal Service publish data about what cases they're seeing, year-on-year analysis, and also the value of those cases. So I'll touch very briefly on some of that, but then also the claims that we're seeing and where they come from. And then, of course, towards the end, I said I'd talk about settlement agreements. I'm not going to spend too long on that. It'll partly overlap with common inquiries anyway. But I also think that if we're going to do settlements, if people are interested in a session talking about settlement agreements in more detail, I'm quite happy to do a dedicated one on those. We touched on them in sort of the resolution session towards the end of last year, but there is plenty more to talk about with them, as I'm sure most of us will be aware. So that's sort of the general overview for today's session. Obviously, as always, I can sort of see the chat QA function on this setup. I'm not in the office, I'm at home, so I've got a slightly different setup than usual. But please do make any comments as you go. If I don't pick them up at the time, I'll have a look at the end and deal with any points that arise at that stage. So, let's start with the common inquiries, the stuff that is coming across our desks all the time, particularly where it's new inquiries from employees. And I suppose indirectly when employers are talking to us about the things that are cropping up for them. That said, the focus is on the first bit, and I think what's useful here is I will be talking to you as an employer lawyer, but with the benefit of being able to think as an employee lawyer. So I'll park settlement agreements because, yes, they are our bread and butter. They are the thing that we're employment solicitors are prepared to act for employees. They come across all the time, and we do sort of deal with somewhere between 2 or 3, maybe 5 a week each, I would have thought, in most cases. So I'll come back to those. I won't talk about them at length for this part of the session. So the other big 3 really are where we can provide assistance to an employee who is going through a disciplinary process, an employee who is trying to preempt their own redundancy, and employees who are dissatisfied with grievance processes or a grievance outcome. And somewhere between those 3, I would say that amounts to 70 or 80% of inquiries, which is surprising, because they're not the ones that necessarily lead directly to an unfair dismissal claim or to a discrimination claim. That they are really the things that we're sort of giving relatively generic advice on, I have to say, on probably an almost daily basis. So let's sort of work through these one at a time. Helping with disciplinary processes, how I've broken this down is what really are the first 4 things that people generally say to us when an employee is contacting us. And it's usually one of these. I've been suspended and I've got an investigation coming up. What do I do? My company are trying to sack me for insert misconduct allegation here. They want assistance with preparing their defence, and that's usually either at investigation stage or for a final hearing. And the ultimate question they're asking, can we as lawyers intervene in that process? And you can see why these 4 questions are being asked. And what I would say is the common theme for all of them is one of 2 things. It's either an employee understandably in a knee-jerk reaction to a situation they don't understand, and as an extension of that, there's a lack of communication going on somewhere, which means the employee doesn't really know where they stand, what's going on, or what process is being followed. And that will be a running theme in what I'm saying today. And I've said it before in these sessions. I've said it in in-person sessions and before we were doing these coffee break briefings. So many issues boil down to a lack of communication and a lack of understanding that can probably be resolved quite early. So I can kind of treat these as maybe 2 overlapping groups. The first 2 probably pull together quite nicely, and as do the second 2. But let's sort of think about this as a process or procedure point. An employee's just been suspended. Now, starting point here is going back to what we talked about with suspension when we were looking at disciplinary and misconduct processes anyway. How this looks from an employee's perspective generally is out of the blue, as far as they're concerned. They are called into a meeting, being told they're under investigation without necessarily really knowing what for, and that they're being suspended. And simultaneously, they're probably being handed a letter confirming that. That letter will almost certainly say, you're not allowed to talk to anybody internally about this. So who do they turn to? They go to the CAB, they go to ACAS, or they come to an employment solicitor because they want to know what's going on and they don't understand. So let's talk about that immediate step for a second first. Consider your decision to suspend in the first place. I think it's an important question, and the advice that we're giving to an employee here is, well, why have you been suspended? What was the basis for that? What do we think the allegation actually is? Does this justify a removal from the workplace? And really, suspension shouldn't be a knee-jerk reaction. It shouldn't just be, we will suspend pending investigation. If you're suspending an employee, it's because either you think there's a serious risk of them repeating the conduct anyway, despite the fact that they're under investigation for it, or that they're in a position where they could somehow interfere with or influence the investigation process itself, whether that's by intimidating other staff, interfering with evidence, deleting information that might be used. As a general rule, you want to reconsider suspension always for 2 reasons. 1, you don't want to pay this individual to be sat at home doing nothing for what could be a very, very long time if your investigation goes on and on. And 2, it is a point that is often challenged in the employment tribunal. I was suspended for a long time. I was removed from my legal right to be in the workplace. I was isolated from my colleagues. And it starts to become an issue on both fronts. So before any employer goes down that process of knee-jerk suspension, it is, I have to say, often a knee-jerk reaction. It is always worth considering whether there's alternative options. Can we have them working in a different environment? Can we put them in a different job role where the misconduct is unlikely to be repeated? Can we have them working, as I say, from a different environment, by which I mean a different office location, a different workplace location? Can we shift their role around slightly so it's something that could be done from home for a short while? Do we actually need to completely remove this person from the workplace? Because for all we say that it is not a disciplinary sanction in and of itself, it will always be perceived as one. And that is one of the main reasons that they go to talk to a lawyer straight away. That said, I have an investigation meeting coming up. Well, at that point, generally, the only advice we can give is your employer is more than entitled to undertake an investigation process. And it really is that simple. Providing it is genuine and there is some underlying belief in the misconduct, you are perfectly entitled to investigate that, to call them into a meeting, whether on notice or not, and to have that initial conversation with them, trying to work out what's happened. I think the problems that arise here, parking the actual question of suspension for a moment, is that very inherent idea that we should not give them a huge amount of information in that immediate moment because they can over-prepare. And it is a difficult one to judge. Do we give them enough information that it might cause us a problem as part of the investigation process? Or do we hold back and take the risk that it's going to cause the employee undue stress? And the answer to that, unfortunately, is the classic, particularly employment lawyers' answer. It does depend. It depends hugely on the circumstances. But I think what needs to be happening at this stage in a lot of the cases that I see is you've got an employee who is suspended pending investigation without really knowing what's going on or why. And I do think it's important to communicate not only the fact of the suspension, but the reason for it. And I think that deals with a lot of questions fairly early on. There's a natural overlap here with the opening conversation we will often have, or it will be written in a new inquiry email, my company are trying to sack me for X. Well, the problem with this is the employee is now going into the process assuming that that is your intended outcome, and they've got that from somewhere. Now, it may well be that the only place they've got that from is that your suspension, investigation, whatever, refers to gross misconduct with the potential for dismissal. There is a sound and solid reason for you doing that. I always advise it if there is any situation from the outset where you can see the potential for a dismissal, that you should be referring to it as gross misconduct from the outset. This is a difficult one to mitigate because if an employee gets into their head that their days are numbered, it's going to be almost impossible to get that out of their heads. What I will say is the advice that most employee lawyers will give in that moment is a very, very similar point. We just don't know yet. This is investigation stage. We can't conclude at the investigation that your employer is trying to terminate your employment. That is something that if the employer is going to follow process and procedure correctly, you're not going to know for probably several weeks. And in theory, the employer shouldn't know for several weeks either, because we all know officially that is a decision that will be taken by a decision maker right at the end. So often the advice that we're giving employees on these two issues is actually let this process run its course for the time being. Unless and until the employer is doing something obviously wrong as part of the process or procedure, or it starts to look predetermined, or there is a clear breach of what they're doing wrong, let the process carry on. Go to the investigation, answer questions briefly but honestly, engage in the process. For the very, very simple reason that the investigation is allowed to continue, and I'll come back to that in a moment. And of course, more importantly, the employer is entitled to run that investigation process, and the outcome could be no further action. Moving on then, the other two are sort of linked here, and they're about the extent to which we as lawyers can get involved in that process in one way or another. So the first one is quite easy. Can an employee instruct us as lawyers to prepare their, quote, defence for them? Yes, of course they can. If they want us in the background to draft a statement to be used at an investigation meeting or in a disciplinary hearing, which they then submit as evidence, yes, they are more than welcome to do that. They're more than entitled to do that, and it is a document that you are going to have to take into account. Absolutely no question about that. Overlapping with can we intervene in the process, and there's sort of various areas for me to talk to about this. We know as a starting point that the legal entitlement to some form of representation in those hearings is at the final disciplinary hearing, and that the statutory right is a trade union rep, trade union official, or a colleague, and that's it. Barring any sort of reasonable adjustment arguments for somebody else, or interpreters for people who maybe English isn't their first language, or responsible adults if you're employing juniors, there's no legal obligation to have anybody else there. There's no legal entitlement for the employee to have anybody else there. The recommendation that we usually give to an employee is that if there is not somebody appropriate falling into one of those categories and they want someone with them for moral support, they should ask. And my advice to you as an employer is generally, providing that person is not going to be disruptive, it's probably better to have someone there than not. But of course, that is entirely your decision. There's no legal obligation to have anybody else present, certainly at investigation meetings, and realistically at disciplinary hearings as well. Can a lawyer otherwise intervene in the process? Well, yes and no. There is absolutely nothing stopping an employee in the middle of a disciplinary investigation or pending a hearing from asking a lawyer to write to their employer and say, my client's involved in this investigation process, we think it's a bit rubbish, what are you doing? As sort of open option one, or as many of you will have experienced before, my client's involved in this investigation process, we think it's rubbish, off the record, we'd like a settlement offer. We can absolutely do both of those things. I suppose the question is how you respond to them and what's likely to happen in that situation. If we intervene too early in this process, the common response from an employer, perfectly understandably, and the one that I would generally advise you to give, is we're in the middle of an investigation, we haven't concluded anything yet, we can't really answer to process, procedure, or this very hypothetical unfair dismissal that you might be suggesting is happening. And that's a perfectly reasonable response because it's true. And in response to the sort of without prejudice offer that classically comes at these times as well, it's almost the same response. As an employer, you're going to stand by your position and say, we haven't done anything wrong yet. On what basis would we be settling this dispute? Why on earth would we want to do that? The third way that we're sometimes asked to intervene, and it's less common, but it does crop up occasionally, is can we stop this process? And the really simple answer to that is no. The only way I can think of legally doing that, barring some of the regulated processes, so police misconduct procedures, for example, where it's technically implemented by statutory instrument, but for 99% of employers who are just following kind of ACAS codes or their own policies and procedures, the only way to achieve this would be an injunction, which would be disproportionately expensive for an employee to go down that process. And I actually don't think would be granted. I really can't see the basis of an application for you must stop this process when there are procedures and legal remedies in place if you think it's done wrong anyway. So in sort of summary with these, the first two of those, the advice that we're generally giving actually is this process needs to run its course. It's very, very hard for us to do anything about an investigation process unless it's clearly fabricated, in which case we might be able to step in and start talking about constructive dismissal, or the way it's being conducted is clearly discriminatory. In terms of the second two, yes, we can absolutely assist in helping you deal with this process. Your employer is not obliged to let us get involved. And even if we do write in directly, educated guess here, what's the employer going to say? We need to wait for our process to be out of the way before we do anything. The only reason that we're likely to get a response to some kind of without prejudice offer at that point is quite simply that the employer is not confident in their own procedures or is very, very keen to get rid of the individual. Counter argument to that, of course, if you were thinking that, then realistically you should have approached with a protected conversation by that point So those are kind of the most common areas that sort of crop up with this help in disciplinary processes. The only other thing I will say on them is just from personal experience that I'll touch on later. But where disciplinary processes and procedures do start to go wrong, and where there is benefits for an employee in engaging us early, is where there are systematic failings in procedure. I've had it happen in a couple of cases over the last few years, and all I have done is advise the employee that something is being done wrong, kept a very, very clear record of that as a timeline. Okay, it's come up somewhat implicitly in an appeal, but actually where 90% of that information ends up is in my claim form in due course. We're under no obligation to tell an employer, while acting for an employee, that they are doing something wrong. I've just seen a question come in, so I'm going to lean down awkwardly and split my screen again and just have a look. So if you receive a solicitor's letter mid-investigation from an employee solicitor, do you have to respond? Can you just ignore? Yeah, you're under absolutely no obligation to reply to an employee solicitor. It may at some point come out as some kind of costs argument. You missed an opportunity to resolve the dispute, but that is so rare in the employment tribunal as an issue anyway that I really don't think it's likely to make much difference. I actually tell employees this. I don't mind telling you all this. It's in my engagement letter when I'm talking to employees about doing that kind of without prejudice or pre-action correspondence. Your employer could just ignore me. I can't force them to respond. And the reason for that, if anybody's interested from an academic point of view, is simply that the employment tribunal is a less formal jurisdiction. That pre-action process, and those of you who are familiar with more civil side of things, that sort of Part 36 settlement offer and all of that, and the formal pre-action steps that have to be taken before you can issue a civil claim, it's just not really there in the employment tribunal. So the process doesn't sort of run in the same way. Okay. Just reset myself for the marketing team. So next question we often have then, preempting redundancies, and again it's a similar set of questions really. I think I'm going to be made redundant. How do I get the best exit package if I'm going to be made redundant? And the one that we're probably seeing increasingly now, can they make me redundant while I'm on sick, on maternity leave, on shared parental leave, some other form of statutory leave? Remarkably similar set of guidance here that I would be giving in the disciplinary situation, funnily enough, and this does again all boil down to communication and what the employee understands. How this situation has usually arisen is it will be the afternoon of or the day after that first announcement where the employer has walked in and said, we're talking about cost saving. I had to mix up cost cutting and cost saving there. We're talking about cost saving and may need to make some potential redundancies. And then they don't tell the employees anything else for a couple of days. That conversation might happen on a Friday lunchtime, just before everybody goes home. And then the employee is going to spend the next 48, 96 hours worried about it and inevitably phone us. So it does, again, really boil down to that communication point, how much you tell them and how quickly that process is going to run. Because the first bit of advice, and really the only bit of advice we can give at this early stage, is, okay, you might be made redundant, and you haven't been yet. It's very, very difficult for us to advise you, employee, on what might happen, what could happen, and what would hypothetically happen if you were made redundant. The initial advice conversation on this is usually what makes a fair redundancy and things to watch for, which is fine. It's helpful to the employee. It tends to calm them down a little bit. The problem is that before they've even started the consultation meetings with you, they've now taken legal advice. They know their rights. They know what to watch for. They probably know a few things to say and a few things to start highlighting. So to me, there is some value in making sure that you're giving more information at an early stage about what's going on, so that they're aware of exactly what process is going to be followed in particular and how that's going to look. Yes, that first initial notification from your point of view is just this is where we are, this is what might happen. But from them, you might as well be standing in front of them and saying some of you are going to lose your jobs, because basically that is what you're saying. So I think just being a little bit more conscious of the amount of information that's being given at that stage is actually potentially going to stave off those employees from contacting the employee lawyer too early. And that can make the process run a little bit more smoothly for you, because again, the same applies. If there's going to be mistakes in a redundancy process, all we're going to do if we're instructed early is start keeping note of them to use later. You know, we're not going to say, oh, you might want to do this because that would be a better way of running this process. It's an overlapping set of advice really with how do I get the best exit package. And actually, again, what it boils down to here is how confident is the employer in their business case for the redundancy in the first place, i.e. is this a legitimate redundancy situation? And B, how confident are we in our selection here? And if both of those things are very, then you're going to be given statutory redundancy, probably with very, very limited recourse afterwards. If there aren't grounds to challenge it, and I'll be honest, redundancy can be hard to challenge. The business case is usually quite well done. So unless there's some major issue with the process or procedure, or the selection itself is somehow discriminatory, redundancies can be really difficult to challenge. The question about how do I get the best exit package actually is only really going to arise in a settlement agreement negotiation where the employer is choosing to go through that process rather than take the risk of a redundancy procedure. That's where how do I get the best exit package is more likely to crop up. Obviously, when employees are having this conversation with us, one thing we can say to them is, well, go straight in and offer yourself a voluntary. Tell your employer you're doing them a favour by choosing to go rather than go through the process, and you might get something more beneficial. But at the end of the day, this is a process that the employer is entitled to follow, providing they do it correctly. There's actually very, very little we can do here. Don't be over scared of the redundancy process. I think what it really boils down to for you as employers is making sure that initial process is there and is in place, i.e. we've got our strong business case for a redundancy in the background, and then that your pool selection and consultation process is thorough, takes into account all the options that avoid compulsory redundancies, and that you are communicating with staff all the way through this process so that they understand what that is going to look like and what is going to happen. Like I say, that very first bullet point, I think I'm going to be made redundant, that arises 99% of the time where all the staff have been told is, we're looking at cost saving, that might mean redundancies. More information there is going to stave off that kind of inquiry. The last one is even more simple. Can they make me redundant while I'm off sick, on maternity leave, whatever, statutory leave? Yes. Yes, they can make you redundant. Indeed, they can dismiss you for almost any reason, providing it's one of the lawful ones, while you're on sick or on maternity leave, providing that reason is established and providing they've otherwise followed a fair and reasonable process. The only thing to be particularly mindful of here is, one, whether the absence is being caused by a potential disability, and you might need to consider reasonable adjustments for the consultation process itself and how the individual engages, and two, your rights in connection with people who are on family-friendly leave at the point of a redundancy, and that now extended protected period for alternative roles. Okay, I've got a question on redundancies, so I really need a new setup here because I'm going to have to keep asking marketing to sort of chop off every time I have to lean down and do this. So, question on redundancies. If reducing 3 manager roles to 1 role that's different but similar, can we select via selection criteria and an interview, or must it purely be based on scoring? Short answer to that is actually whichever you think is the most appropriate way of doing it. Providing that your process is transparent, fair and non-discriminatory, you have actually got a choice there. You can go down the selection criteria route, of course, to narrow it down in the first instance if you wanted to, but the performance in the interview for it could in theory be part of your selection criteria anyway. So there's no sort of clear answer to that one, because you could well go through a bit of both, which I appreciate is not the most helpful response. Second question on redundancies: do I have to follow a redundancy process if I want to reduce the hours of all your employees by 1 day a week but not make any redundant? No, if you're not saying that there's a redundancy process, if there's not a redundancy situation and the redundancy process doesn't trigger, that's a change in terms question, I think, in the first instance, but there is still a consultation obligation because you're trying to change everybody's fundamental contractual terms. It's only going to become a redundancy situation if you then need to reduce the number of roles, I think, in my view. That's more so where it boils down to. It's the number of roles reduction, I think, is what would trigger an actual redundancy process there. It does depend on your background reason for it, though, and what the reduction in the change of day and change of hours is actually caused by. Okay, third common question, and I'm going to have to speed up here a little bit. I'm happy with the grievance process. This is a much shorter one, and I think the fundamental problem with grievances is an employee is almost never going to be happy with the result. And the reason they're never going to be happy with the result is because they want one of three things. They either want you to admit you were wrong, they want you to somehow change some term or benefit that they get, or quite commonly, they want you to sack somebody for a perceived slight. In return, as an employer, you absolutely do not want to admit in writing that you were wrong, change an employee's terms to their benefit unless you have to, or sack somebody because you're being told to. That is the fundamental problem with the grievance process. And that is why the most common responses we get, the most common queries we have are, I've done a grievance, the outcome isn't what I wanted, it's been fully rejected and that's unfair, or the grievance has been partly upheld, but they haven't implemented any kind of remedy. Fine, these are common responses. They're the responses that I would expect most of you to be giving to most of your grievances, for the simple reason I gave at the start. Where the advice usually goes in a grievance situation is in one of two routes. Either the thing they've complained about is discriminatory, and then we start to make the argument that the employer is now not dealing with the discrimination issue properly, or where it's something maybe slightly more direct than that, if it's to do with bullying, if it's to do with line management structures, if it's to do with an issue with paying conditions that's not an equal pay issue, then this might be leading towards a constructive dismissal claim. Now, on the discrimination side, this is quite easy. If we can see the discrimination and we can see that the employer's covering it up, then the failure to uphold the grievance starts to play into an argument around how the employer is dealing with the discrimination in the first place. You don't get out of a discrimination claim by concluding in your grievance that it didn't happen if you've got any reason to suspect it did, or if objectively a tribunal would conclude it did. So do be careful of that. On the other side, of course, the constructive dismissal claims, I've talked about these briefly in a previous session, they are harder to bring. And an employee is going to have to argue that the failure to uphold the grievance was in and of itself part of that fundamental breach. Which I think is quite difficult to do. So it is quite common that we find ourselves talking to employees going through the grievance process to do that tick box exercise, building towards a constructive dismissal, and a grievance outcome that's not satisfactory, that's not in accordance with policy, that doesn't properly consider the actual underlying issue, could then be the trigger event to give rise to a resignation for a constructive dismissal claim. But it is so fact dependent that one of these 3 points in and of itself does not necessarily make a constructive dismissal claim. Now, that's not to say that we can sort of fob people off with grievances or do as little as we can. They do still need to be investigated properly. You've got an ACAS code to follow. It's probably quasi-contractual that you should be going through a grievance procedure in a certain way regardless. But on the question specifically of outcome, providing it's a justified outcome that makes sense, considers all the relevant information, is the outcome of a reasonable investigation, This again can be something that's quite hard to challenge. And we know realistically that kind of unfair dismissal claims in particular, ignoring any kind of discrimination, are arguably the one area of employment law that is slightly on the employer's side, partly because of their value, and partly, particularly with constructive dismissal claims, the difficulty of getting over that hurdle of proving there's been a breach in the first place. I've got 2 more questions in, so I'll have a quick look at those before I move on. Okay, let's go back to redundancies. I think they're 2 related points. So we have a redundancy and there's a vacant role that we don't think the person is suited for. Should we offer an interview trial period or just not consider the vacancy? Did I see there's a related point underneath that? The vacant role is not the same role that's being made redundant. Okay, so just very, very briefly, I feel like I may end up doing a whole session on redundancies as a result of some of these questions. So if that would be helpful, please do kind of let me know, folks. I think my answer to that is how a suitable alternative vacancy role works is you offer it to a person who has been selected for redundancy and is likely to be made redundant. It's only going to be applicable if it is suitable, which does mean it falls within their skill set, their pay banding, and all of those sorts of things. If an employee unreasonably rejects a suitable alternative role, they lose their entitlement to statutory redundancy. Okay, so that's the kind of official concept of suitable alternative vacancy. In terms of offering any role as alternative employment, no, your obligation is to consider whether there is a different role in the organisation that the employee could do or could apply for. But if the application process is ultimately, and you can tell this from the start by the sound of it, going to conclude that they're not qualified for that job, then it doesn't sound like something worth pursuing to me. I don't think it's going to make your redundancy process inherently unfair to say we did have this gap in the business, but it's absolutely not one that you would have been qualified for. It may be worth bringing up in consultation, because if they agree with you that they wouldn't fit into that space at all, then you've done your obligation, you've considered it and concluded as to why it's not an option. Okay, going to touch very, very briefly on sickness absence management processes, because this is coming up time and time again. Usually, I think it's because you as the employer feel stuck. And I think part of the problem with that is not engaging in the process early enough. The public sector is particularly bad at this, at leaving people sat on sick leave for a very, very long time without engaging in any kind of absence management process. So I've said there, the need is to engage and engage early. Look over your absence management processes, look over your absence management procedures, because I think the last thing an employer really wants is somebody sat on sick leave for months and months and months and months. 2 reasons for that. One, whatever that condition was 6 months ago is now 6, 7 months down the line, increasingly looking as though it could be a disability when it probably wasn't back in June when this process started. And then the moment you're starting to suspect a disability, you've got all of the associated issues that arise with that. The second reason we don't want somebody sat on sickness absence for a long time is that they're on the books, they're racking up accrued service, and they may well be taking that time to consider their options. Don't forget, there's not an unfair dismissal claim until they're dismissed. So it's not as if we're helping ourselves get over any kind of ACAS timeline or anything here by having them sat on sick leave for a long time. And I think where this stems from is an uncertainty about your own policies and procedures as to whether it's capability, whether it's a disciplinary issue, whether we should be looking at a settled exit, at what point we engage occupational health. What I suggest, go back over the session on sickness absence management and also the much longer Q&A one that we did talking about the engagement of occupational health. But do engage with these processes early. The moment somebody is starting to roll into that mid to long term sickness absence, the moment it looks like this absence could be lasting for more than a couple of weeks or be in connection with something that is likely to become ongoing, start talking about that viability. It is not going to give rise, providing you do it compassionately, it is not going to give rise to a discrimination claim to sit down with an employee and say, look, we're aware of this condition, we're aware of the sickness absences, let's have an open conversation about where this is going to go moving forward, what we might need to do for you, what you see as your prognosis and your future with us. And do engage occupational health at an early stage as well, because if the conclusion from the employee and the conclusion from occupational health is that there may not be any adjustment that could be done to the workplace that will bring this person back up to capacity, then you've got the information in front of you to make a decision as to whether or not that person can remain employed. Very, very brief overview because I'm conscious of time and I can see questions coming in on anything else. So again, if this is something that we want a longer session on in more detail, please let me know. I just wanted to flag it as something that's cropping up all the time at the moment. I can see questions coming in, particularly on redundancies and things like that. I'll come back to them at the end if I've got time. I'll get through the session first, if that's all right with everyone. So top tribunal claims, I mentioned at the start that some of this is coming from the statistics that the tribunal sets out itself. So looking at the last quarter of 23-24, 13% year-on-year increase in claims in that time. That said, we are slightly down on sort of 21-22. And that's simply because, funnily enough, we're not getting that huge wave of claims that came after the end of COVID, and particularly all of the no jab, no jobs, which some of you will be more than familiar with. You'll see a slight variation in that 13% number. Some of the statistics that people are choosing to use online talk about the difference between single party and multi-party claims, and some of them are looking at the entire year versus just a quarter. But it does seem to be somewhere between about 9 and 13%. The statistics that the tribunal released through 23 and 24 placed particular emphasis on discrimination claims and their value, which are going up. They're going up because people are bringing higher financial loss claims arising from discrimination, and of course because the injury to feeling Vento band awards go up every year anyway. So as I said there, average award for a disability claim is currently sitting at about 45,000. Now we've got to bear in mind that that accounts for the ones that are £1,200 and also accounts for the sort of 1.4 million claims that you very occasionally read about. But if an employee is being told that it might cost them 10, 15, 20 to bring a claim, and they could walk away with 44, 45, then you can see why claims are still being pursued. There is still financial benefit in doing so. Insured claimants in particular, of course, looking at that figure and going, well, I don't even have to pay for this, and I might walk away with £45,000. So there is still value for claimants in pursuing these claims, and that's the reason why the tribunal levels are still as high as they are. So what are the most common ones we're seeing? Well, I'm quite happy to talk from personal experience on a few of mine. I can't see them in front of me, they're on a whiteboard behind the camera. Almost all of my current ongoing cases where I'm acting for a claimant arise either from disability or disciplinary or disability discrimination issues. So the ones that are to do with disciplinaries are almost exclusively unfair dismissal claims, as you might imagine, and they come from one of 2 points, both of which I mentioned earlier. Either they are a poorly managed process, or there has been a lack of communication between the employer and the employee as to process. And actually, in all of the cases I'm working on at the moment to do with those, we're arguing a combination of substantive unfairness, i.e. this process has been so poorly managed that you, employer, haven't actually reached your threshold. You haven't shown that something justifying dismissal took place. Forget show it as a reasonable conclusion. Or what's happened is there's been that usual breakdown between sort of investigator stroke HR and the individual themselves. And we all know a common dispute there is around sort of meeting notes and records of conversations and things like that, all of which do routinely arise. Again, one of those cases is one of those examples where I was instructed very early. It was pre-investigation stage. And all we've been doing, like I suggested before, is keeping track of every time something goes wrong. And that made drafting my claim form very, very easy for me. Discrimination claims that we're seeing where they particularly relate to disability, the two big increases, the overlap of disability sex claims and menopause. And just to be absolutely clear here, I always always say when I talk about this, the menopause is not in and of itself a disability. All of the cases around it refer to effects, symptoms, and impact of conditions on individuals. That's the legal test for a disability. There's only a handful of conditions that are by statute automatic disabilities. It's very, very unusual for a tribunal to conclude that a specific condition amounts to a disability. But we are seeing those claims. I've run a handful of them in the last couple of years, and so far the majority of them have had the combined symptoms of menopause for my individual client to be deemed a disability, and 2 of them did make their way to en route to final hearings. So these cases are arising. The other very, very common one that's being talked about a lot, of course, is disability from the perspective of neurological and mental health conditions. I won't say too much on those because that is something I absolutely could talk about for hours, but do be mindful of these. I think where those claims are arising, and certainly where I'm seeing them being pleaded, both as an employee lawyer and as an employer lawyer, is from a lack of understanding or a choice not to engage. So to take sort of an example, you will have an employee who says, I am neurodivergent in whatever way, I've got ADHD, for example, maybe. This is the effect it has on me in general terms. Can we just be mindful of that, please? You then unfortunately have an employer, or usually an individual line manager, who doesn't want to engage in that, or chooses not to engage in that, doesn't educate themselves, and ends up saying or doing something that they shouldn't. Now, the problem with that is if we can establish that the underlying condition, the underlying neurodivergency is a disability, then that hands quite an easy Section 15 claim, discrimination arising from, simply because of something that has been said or done or not done that could have very easily been remedied. Now, nobody is suggesting that every single employer and line manager should be an expert on every conceivable disability and neurodivergency. But when they are flagged to you, when it is something that is quite common, like somebody with ASD, like somebody with ADHD, then there are very, very easy resources available and accessible to you to work out what may or may not work with individual employees in those situations. So do be mindful of that, because it is such a current thing, it is such a big issue, it is something that is being seen in the tribunal all the time. Very quickly, I'll just stick on a couple of sticking points on settlement agreements, but I think by the sound of it, some of the additional queries and questions that are coming in, I may end up doing a session on settlement agreements anyway. The 2 big sticking points when we're negotiating these for me in the last few months. 1, notice periods. Don't ask me why this is a particularly controversial question. I think it's probably to do with financial value, but who is giving notice to whom? It's a question that I seem to have cropping up all the time, because there's usually a difference in the length of the relevant notice period. Funnily enough, as an employer, you want it to be the smaller of the 2 conceivable notice periods. The employee is always going to want it to be the bigger of the 2. There's no hard and fast rule on this, but as a general principle, if it is a redundancy-based settlement agreement, even if you're not calling it a redundancy, I would say it's you as the employer who is terminating in that situation. Where the dispute usually arises is where it's unclear what's going on and whether this is just by mutual agreement. Is the employee resigning? Are they being dismissed? If so, which notice period is applicable? Obviously, it makes no difference from a tax point of view. Notice period is always going to be taxable, but it could be the difference between 3, 4, 5 weeks that the employee may have to give, or 3 months the other way around, or vice versa, depending on your contract. What I will say, the risk of getting this wrong, of course, is that HMRC conclude that you're wrong and therefore decide that some of the ex gratia payment was actually disguised notice pay. So it is important to consider exactly what the mechanics are of this when giving instructions on notice periods and making offers. The other big one that seems to be cropping up more frequently is around references and announcements. I've had solicitors acting for employers in this situation who have been reluctant to add a line allowing an employee to talk about their employment history, for example, when talking to a prospective employer. And I do find that a little bit odd. And I think the problem from the employee's side here does come from, well, how do I ever tell somebody what's happened? I've just suddenly left my job. I might have a gap in my employment history. I'm inevitably going to be asked the question of, why did you leave company A before you knew you had a new job lined up? And I'm left with a difficulty as to how I answer that question. I think this is a case of being reasonable. There's always ways of caveating announcements and references and what statements an employee can and can't make and to whom. But to have an absolute blanket, no, this is absolutely confidential, apart from to your family, professional advisors or HMRC, which are the usual exceptions, is probably increasingly unreasonable and unfair, in my opinion. I think there always needs to be some allowance for an employee to not be missing out or having to fabricate statements made to other people, just for the sake of absolute confidentiality. But again, they're just a couple of the big ones that I've noticed on settlement agreements in the last few weeks and months. Again, if anybody does want us to look at settlement agreements in more detail, then we will do so. So just to wrap up today's session, the next one will be on Wednesday, the 5th of March. We've decided to do another kind of overview discussion. I'm going to get Nathan back on board for that one. The two of us will be presenting it together as the current plan. We'll be talking about good HR practice and the overlap between legal and HR. In effect, how to get the most out of each other, what we as lawyers want from HR professionals, and vice versa, how we can help each other out so that there aren't as many issues in the future, or that we can mitigate them as best we can. I'll go through questions in a moment, but what I'll do now is sign this off and wish those of you who need to go now, because we're just coming up to 11 o'clock, I think, a very good rest of your day, rest of your month, and I will see you in March. For anybody who does want to stay, I'll go through the questions as best I can, but otherwise, thank you as always for joining us.